Deputy Durkan, this is part of your ongoing crusade.
Thank you.
Thank
you, Can Corla, and thank you for allowing me to present to the House again. This relates, of course, to the ongoing difficulty in family law cases whereby a concept that is not recognised or is not supported but is strongly contested nationally and internationally by various proponents and opponents, to the effect that women who are mothers and their children are forcibly separated. It also applies to some men, and only allowed under very special situations to speak over the telephone. And in some cases they're separated for a number of years, with obvious consequential hardship and stress to the parents, and also obviously in danger of creating serious health and mental health problems for the children. It sounds unreal, and very few people will believe that it happens, but it happens under the cover of the in-camera rule, where anything can happen and cannot be reported outside and isn't reported outside, and TUSLA cannot intervene because TUSLA is subject to the in-camera rule as well. And it has been used extensively by Mr. Jim Sheehan, whom I've mentioned before in the House, and a number of his cohorts. It is a very lucrative campaign in the sense that it costs about €8,000 for every report, and it's supposed to be an expert report. It subsequently transpired that not all the people who make these reports are experts or have any competence at all in the particular area. But without saying this was eventually any more about, this was taken up by the Special Rapporteur on Human Rights in the UN. And to such an extent that she made a recommendation to the effect that the concept be legislated for and stricken off the books and stricken out of the jungle, and to be expunged completely from any form or shape of use or anything like it in family law cases in the future. This will have the effect of at least having a level playing field when such cases are being discussed. It will mean that the terrible burden and the stress that is being caused to many parents all over the country will be lifted. It will also mean then when the states and this state and other states legislate to eliminate it, that no other concept, similar pseudo-concept, can be reintroduced, as it were, under the radar in order to do the same job. It is not necessary. It is not necessary in law. It is not in accord with the Constitution. It is not in accord with the civil rights or the human rights of the individuals. And it is sad to say that we in this country, in a freedom-loving country, and that we boast, and rightly so, of our freedom, all the freedoms that are available through the membership of the European Union and in this country as a republic itself. It is sad that this practice continues. And in the first instance, I ask that the legislation be seriously considered in the shortest possible time in order to address what is a scandal and a serious blot on our society that this allows to happen, albeit under the in-camera rule.
Minister, please, and thank you for being here to deal with this.
Thanks very much, Ceann Comhairle, and I want to convey my apology on behalf of my colleague, Minister for Justice, Helen McEntee, who cannot be here matter due to another commitment. Can I thank Deputy Durkan for raising this important matter today and give me the opportunity to provide clarity on some of the issues he has raised. And Deputy Durkan, I acknowledge that this is an issue you've campaigned on. And as the Deputy is aware, just in context, management of courts, operational matters and logistical functions are the responsibility of the judiciary and court service, which are independent exercise their functions under the Courts Act 1998. And given the separation of powers and Constitution, therefore I am unable to comment on any individual case or categories of cases. However, it may interest the Deputy to know that last year the Department of Justice committed to undertake both in public consultation and independent research on the topic of parental alienation as part of the Justice Plan 2022. The findings of both were analysed, and arising from this, officials in the Department of Justice developed a policy paper on how to address the issue. Minister Harris, then the acting Justice Minister, brought both the finalised policy paper and the research report to government on the 23rd of March last, which noted his intention to publish both reports. Both the research report and the policy paper have now been published on the Department's website. Both the paper and the report recognise that parental alienation is a highly contested and divisive concept. While there is little concrete information on the exact extent of accusations of parental alienation within the Irish courts, the research report found that, similar to other courts internationally, there appears to be increasing claims of parental alienation in family law proceedings. It appears to arise particularly in custody and access disputes in cases where allegations of domestic, sexual and gender-based violence feature. Despite the highly contested nature of the concept, there was a consensus in the public consultation that the means to address parental alienation lies in improvements to the Irish family courts and family justice system. Parliament is currently leading on an ambitious programme of family justice reform, including the publication of the Family Justice and Family Courts Bill 2022. The strategy puts children at the centre of the system and emphasises, amongst other things, the need to ensure that they are listened to and heard and their views given due regard in line with constitutional obligations and rights. Reflecting this, the policy paper puts forward 6 recommendations to address the issues of parental alienation. They centre on progressing elements of family justice reform, building the system's capacity to adequately hear the voice of children, and improve the knowledge, skills and experience of all those involved in order to make the determinations in relation to each case and its own merits. This is especially important in high conflict cases in which allegations of parental alienation can often arise. The report of the UN Special Rapporteur on Violence Against Women and Girls, its cause and consequences, Reem Azalam, which considers the abuse of the term parental alienation and deliberations of the United Nations Rights Council and report in the coming months will be fully considered as the work in this area is advanced. And as I said, the family justice strategy is an ambitious and wide-reaching strategy which aims to achieve reform through the implementation of over 50 actions across 9 goals. It priorises the needs and the voices of the child, containing a number of actions which stress the importance of children, their needs in the reformed family justice system, and their voices are heard and views considered in a meaningful way. These include an examination of the role of expert reports, including under Section 47 and 32 reports in the family law process, the commissioning availability of these reports, their content and use, and the registration and other requirements of the various professions providing these services.
Thank you, Minister, for your reply, and I acknowledge that the Minister for Justice and the Acting Minister for Justice have done tremendous work in advancing the cause that I referred to in dealing with it. Excuse me. The position is that in some cases, children are subjected to being screamed at, being told to shut up and sit down. Their mothers are being told to shut up and sit down, or they might never see their children again. This has happened and is happening under the in-camera rule at the present time. The concept of parental alienation there's no such concept, except in the minds and the imagination of a number of people who have a vested interest in it. And the concept was first discovered, as somebody said to me recently, 100 years ago by a gentleman in the United States. Well, we've progressed somewhat in the 100 years, and this is one area we have to progress a little bit more. I think that to bring the story to a conclusion, we need to legislate separately and urgently to remove the concept from the legislature altogether, and to ensure that it cannot be used again in any other shape or form, or any pretence to bring it before or to legalise it and to set it up in the future. There are situations at the moment where up to 500,000 has been requested as a means of bargaining in order that the parent might be allowed to see their children who have been transported outside the jurisdiction. This kind of thing cannot go on. I thought we'd dealt with this many, many years ago when we talked about women's rights and equality and all the things and the legislation that we've referred to in this debate. And to bring to the attention of the House that this continues regardless. And there is no intention on the part of the perpetrators to deviate in one iota from what they have been doing and continue to do, and the reason is simply it's lucrative. So I would ask that the intervention be serious and relevant and early.
Minister.
Once again, on behalf of Minister McEntee, I would like to thank Deputy for raising this matter here today. And the specific point you raise, Deputy Durkan, I will take back to Minister McEntee. As you're probably aware, Minister Helen McEntee has published the first family justice strategy in November of last year, which sets out a vision for a family justice system of the future. This will be a system that focuses on the needs and rights of children, a system that assists their parents in making decisions that affect all the family, and a system that makes it easier for vulnerable parents and families to get support to make informed decisions. Strategy is founded in nature, recognising that many issues that currently exist within the system, but outlining the steps needed to move towards a family justice system that is streamlined and user-friendly and which supports and protects children and their families. And just to, I suppose, to reiterate, the family justice system is an ambitious and wide-ranging strategy which aims to achieve reform through the implementation of over 50 actions across 9 goals. Prize the need and voices of the child, containing a number of actions to stress the importance of children, their needs in reform family justice system, and their voices are heard and views considered. And as just to state, an examination is underway on the role of expert reports, including Section 47 and 32 reports, in the family law process, the commissioning and availability of these reports, their use and content, and the registration of the requirements of the various professions proving their services. And I will ask the specific point you raise, Deputy Durkan, that will form part of this examination. Thank you.